Hello, everyone, and I'll just check this is recording. Yes. Hello, everyone. Welcome to week 7 for International Environmental Law. Um, I hope you've had a nice mid-semester break and you're ready to go for the second half of semester. I'm looking forward to the latter half of the semester as well because we do even more active activities during our classes, and I start introducing some of my board games that I've made for international law, and I have some card games that I've actually got from The Hague as well. So there's a lot of fun things coming up in our classes from here until the end of semester. So hopefully a lot of things to look forward to as well. Um, Also, I just want to draw your attention to the week 6 makeup recording. I apologize again for missing our week 6 class because of significant internet issues I was having. I did a little makeup recording, which is in the after class activities for that particular week. So it's just 20 minutes, and I just go through some of the main points from last week's tutorials. And I also just point out that for your assignment 2, which is due in a couple of weeks or a few weeks' time, um, I have placed a slide deck which goes through some aspects of writing a memo. And I've put that slide deck on the assignment 2 Canvas page. I think it's close to the bottom, but you'll see it there. It's the only PowerPoint slides that are on that page. I think many of you will be familiar with writing a memo, but it kind of approaches it from the aspects of international law. So hopefully it'll be a little bit useful. It's just something I've kind of just whacked together. Um, but it is there if you'd like to check it out, and just be mindful as well of the criteria for the assignment 2. Hopefully, by the time you listen to this, you should have your assignment 1 results back and feedback, most importantly. There has just been a little bit of a delay just because we had some late submissions. I was also traveling overseas and had gigantic delays in my travel time as well. So there's just been a little bit of a delay, but hopefully you'll either have it now or very soon. And very happy to also talk more about it if you'd like. But let's just go back to this week's content because we've got a very important topic, which is environmental law. So just like always, I'm trying to present some aspects of this topic, which, while addressed by your textbook, I've tried to go in a little bit more detail or approach it from a slightly different angle. I don't go through every single point that your textbook does, just because it actually deals with a hugely extensive breadth of detail in your chapter, but I just kind of focus on some particular points for emphasis. Um, so this is what we are looking at today, doing a bit of an overview, and I'm focusing on the development of international environmental law, adding a bit more in your textbook. I just do very briefly on the sources. I think your textbook does really well there. And then I go in a lot more detail about the principles of international environmental law and then some environmental law issues. So this is kind of what the overview is looking like for our lecture today. Now, let me just see if I can get rid of my little thing at the top. Yeah, sorry, there we go. I still can't work out how to get rid of those grey boxes, but international environmental law is obviously a very, very important topic for international law and in general. And it's also vital for us to think about as international lawyers because it is a area that really has no boundaries. So if all humanity is on a ship called planet Earth, any damage to this potential ship will cause the destruction and decay of the entire human society and will be thrown overboard. So it's a really vital topic. And in the broader context of this area, as it has developed and expanded in the legal field, there's also been links to different aspects of international law too, such as different rights, so like the rights to healthy environment. It's focused on like common heritages of humanity, the rights of future generations, and also rights to development have all kind of been crystallized around the broader area of international environmental law as well. And what we call like the environment is also quite broadly construed. It comprises like the air, water, land in and around us, in which like people, animals, and plants live. Unfortunately, I don't really go much into animal law here. I mean, I'm not actually entirely sure if RMIT offers a separate subject on this, but it is a whole area of law in and of itself, which is also really interesting and really vital and has a lot of intersections here. But as we can tell, like the environment is a really balanced set of biological elements that surround our bodies that we interact with. So it includes things that are also not limited to spaces, resources, land itself, marine environments, different landscapes, air quality, living and non-living beings, biodiversity, biological processes, soils, and geodiversity as well. So like international environmental law is concerned with protecting all of these things under this broader idea of the global environment by generally applying like legal norms and regulations that address transboundary, regional, or global environmental issues. Now, importantly, in its most recent sixth assessment report, the International Intergovernmental Panel on Climate Change, or the IPCC, which is the lead scientific body on climate change, has noted that climate change is already affecting every region across the globe. It's altering the frequency and intensity of heat waves, causing heavy precipitations, droughts, and tropical cyclones. And the report has projected about a continuous increase in the global surface temperature until the mid-century, which has become increasingly evident. And even the World Meteorological Organization has corroborated in these warnings, stating that there's a 66% likelihood that the annual average global temperature will exceed 1.5 degrees above pre-industrial levels for at least 1 year between 2023 and 2027. So there's a lot of really compelling evidence here, and so it's obviously very important to reduce greenhouse gas emissions in the following decades. But these complexities of climate change, extend beyond a simple correlation between human-induced emissions and also an amplified greenhouse effect, on which the IPCC concentrates on many of its earliest reports as well. But it's also inherently entwined with how current socioeconomic and political systems function and distribute resources. For example, if we have a look at a recent World Bank report, sorry, not World Bank, I think it was Oxfam. It's noted that the richest 10% of the global population is responsible for half of all CO2 emissions, whereas the bottom 50%, which is those who are generally living below the poverty line, generate only 16% of emissions. So these groups, which are of lower socioeconomic status or lower class, they experience different forms of social exclusion due to gender, race, ethnicity, class, and they also bear a disproportionate burden of climate change impacts given their limited coping mechanisms and resources as well. So between 2010 and 2020, these populations suffered 15 times higher mortality from climate-induced disasters than those in less vulnerable socioeconomic circumstances. So this is a really important issue that cuts across lots of different lines and has a particularly intersecting disproportionate impact on people of diverse like racial, ethnic, and class backgrounds. So this is kind of a broad overview of this topic and, why are we looking at it? Now, the development of international law is also something your textbook goes into. And I'm just going to expand on it ever so slightly here because I think the history is always important to know about the various topics that we study. But if we can like point to international environmental law, it really kind of became its own branch of public international law somewhere in the 1970s. The focus on like the conservation of species of animals and plants does date back to before this time, and there's been other bases for international environmental law, how it's developed in its modern kind of concept. And one of these, which I'll talk about a little bit later, is the Stockholm Declaration of the United Nations Conference on the Human Environment in 1972. And this is kind of where the modern international environmental law kind of began. But if we're thinking about this whole area historically, we can divide it into three different periods and defined by generations, as I've got on the slide here. So the first generation, this began in like the 18th century, and this included the signing of bilateral agreements in the field of fisheries and marine life resources. And the most important feature of this really early kind of evidence of international environmental law is the aspect of regionalism and the creation of contractual obligations between governments to protect a specific region or species. One example that I found of this of these treaties is the treaty concerning the regulation of salmon fishery in the Rhine River Basin on 30th of June 1885. So even in some of these bilateral treaties where there's kind of this contractual obligation to protect certain wildlife or water areas, for example, we're very much based on these on bilateralism. And also focused on, I guess, more the economic aspects of conservation. Now, the second generation saw an expansion of international environmental law into the focus on broader fields, into like wildlife, rare and endangered plants and animal species in the early 20th century. And then the most kind of prevalent kind of progression of this field is, was in the 1960s. And this was also importantly known as a decade of student movements, of progressive movements, especially happening around the world. And it marked a turning point in the destructive process of modernity as well. And the social movements at this time wanted to address lots of fundamental issues, including environmental matters, and especially again as that environmental destruction became more and more obvious around the world. So environmental activists and scientists around this time declared that if industrial progress continued the same way, the world would eventually be destroyed. And so this is why by the beginning of the 1970s, states were forced to hold the Stockholm Conference. And the purpose of this conference was to pay attention to the world's environmental issues and their relationship with human rights, to warn of the harmful effects of human activities on the environment. And the Stockholm Conference recognized the right of development to be closely linked to the environment by identifying the right to a healthy environment as a fundamental human right. And in this kind of conference, there was this consideration of the necessity of international institutions to also integrate cooperation in the field of the environment, which is also why we see one of our important principles, that of cooperation in international environmental law. And this conference, the Stockholm Conference, provided the direction for further development and evolution of the relevant international rules to protect the global environment. And the main outcome kind of document of this conference, which is the Stockholm Declaration of 1972, recognized 26 principles of international environmental law. And this declaration stated that environmental issues should be at the forefront of international concerns, and it marked the start of some kind of dialogue between developed and developing countries on the link between economic growth, the pollution of air, water, and oceans, and the well-being of people around the world. So this Stockholm Declaration, coming from the Stockholm Conference, really strongly influenced the further development of international environmental law. And one of the important outcomes of the conference as well, besides the declaration, was the establishment of an international body, the United Nations Environment Programme, which is an environmental program that has now become one of the most important pillars of environmental practices and protection as well. And the United Nations Environment Programme, or UNEP, is it has one of the important functions of it is performing the global environmental assessment, which publishes a collection annually that describes the state of the world's environment. It also tries to coordinate and manage the world's environmental protection in cooperation with states worldwide as well. So after the Stockholm Conference and these like important declarations, the establishment of the UNEP, environmental protection became the subject of several treaties and declarations, which kind of illustrated a new willingness of the international community to protect the environment, encourage sustainable development, and tried to address the imbalance between the so-called global north and global south. I mean, a lot of this was also wrapped up in geopolitical concerns of the Cold War too, and the so-called global north wanted to be seen to be responsive to the demands of the global south. Um, which is also an important aspect of this period of time. Now, the third generation takes us after the end of the Cold War into the 1990s. And this really began in earnest with the 1992 United Nations Conference on Environment and Development, or otherwise known as the Rio Conference, because it was held in Rio de Janeiro in Brazil. And in discussing the environment as a global problem, the Rio conference stressed, that there's a need to coordinate the development process of countries with the protection of the environment. This conference introduced environmental protection as an essential international issue for the next century. And the subsequent declaration that came from that conference, otherwise known as the Rio Declaration, affirmed that states should always be concerned with environmental preoccupations in economic development and industrial growth, and that states need to consider the principles of sustainable development in the formulation of their programmatic and other ordinary laws, as well as when they're making and drafting and then forming bilateral or multilateral binding instruments. And that the declaration went on to say the state should recognize the role of social groups, non-governmental organizations in protecting the national, regional, and global environment. And then about 10 years later, another kind of important milestone on the development of international environmental law was the organization of the 2002 World Summit on Sustainable Development in Johannesburg. And this conference was important too because it announced the 8 Millennial Development Goals for development, which is also very important. And kind of related to that was the subsequent 2030 Agenda for Sustainable Development. This was when the Millennial Development Goals had basically failed. And then the new movement towards the Sustainable Development Goals was initiated by the 2030 Agenda for Sustainable Development. And the purpose of the agenda was a plan of action for sustainable development to strengthen universal peace and eradicate poverty. And as your book goes into a bit of detail here, there were 17 sustainable development goals, 169 targets that demonstrated the scale and ambition of this new agenda as it tried to build on the Millennial Development Goals and complete what they didn't achieve, which was, unfortunately quite a lot. It kind of centered the human rights of all and achieving gender equality and empowerment of all women and girls, and also had a big focus on the environment as well. And around the same time, the 2015 Paris Agreement, which many of you might have heard of and be aware of, and certainly textbook mentions it too. This agreement on climate change was another really significant collective initiative by the international community to address this global problem. And the agreement aimed to limit global warming to less than 2 degrees above pre-industrial levels and strive to limit temperature increases to 1.5 degrees. And importantly, too, the Human Rights Council of the United Nations in late 2021 also adopted a resolution recognizing the human right to a clean, healthy, and sustainable environment as well. So these are kind of some of the main points on the way of modern development of international environmental law. And we will kind of talk about, where has that left us today a little bit later on too. I'm just drinking a drink called Samahan. It's a Sri Lankan drink. It's really, really nice. But it also helps you when you're a little bit clogged up, because I feel a little bit clogged up after travel. So if I also don't sound perfect like my usual self, it's because of that. But I'm trying to fix the problem as we're going. Summer Hunt, it's really good. Check it out. Now, let's briefly talk about the sources. So, just very briefly, because your textbook does a much better job at this. But international environmental law also, uses very similar sources from broader public international law. Um, Treaties are very important, and the really vital environmental conventions are like the United Nations Framework Convention on Climate Change or the UNFCCC, the Kyoto Protocol, which we don't talk about too much, but is also very interesting in the development of international environmental law. And I mean, if you're ever interested in seeing the politics of environmental law. The Kyoto Protocol one is a good one, and also Australia's position in it, because Australia secured kind of really crazy concessions in that protocol, which basically made our ability to meet targets, ridiculous easy and totally a total kind of superficial exercise because it wasn't really based in reality. But I mean, we can't go into it in too much detail, unfortunately. But it's something I talk to my public law students about. It's quite an interesting demonstration of the politics of law. And then the other also important convention we've already noted about it is the 2015 Paris Agreement on climate change, and there's dozens upon dozens more that exist. Um, but although we have these conventions and they've been signed, accepted, and even ratified by a majority of states, the commitments made by the states do seem minimalist and insufficient concerning the gravity of the problems and challenges facing the development of international environmental law. Um, we also have soft law or customary law, which is not binding, but it does have also a crucial impact on the development of this field. And some of the most significant examples are like the sources we've already mentioned, like the 1972 Stockholm Declaration. There's also the 1982 Universal Charter of Nature, the 1992 Rio Declaration, which I mentioned, is also the Agenda 2030 for Sustainable Development as well. So just a very brief comment on the actual sources. Now, I'll go a bit more into the principles here because I mean, I think your textbook did do very well with the principles, and I think it really highlighted like three or four of them. And I'm just going to put a few more in here for your consideration as well. And I mean, these are important too because they're kind of the basic ideas for the development of this field of law. Some of them we can find enshrined in multilateral environmental agreements. And there they have a really clear meaning for the specific international environmental regime. But if a treaty doesn't explicitly recognize a principle in its text, a principle which you can read between the lines can still play a really important role in interpretation and development of the treaty itself. So one of the other reasons why it's important to note these principles of international environmental law, and they can also supplement specific rules and express some kind of gap-filling functions as well. So the first one I'll mention here is the principle of cooperation. And this is a broader principle because it's a customary obligation and one of the inseparable principles of the United Nations Charter. And it's one of the broader features of contemporary international law as well. And it is said to be a really strong binding principle. And similarly, protection of the global environment is beyond the capacity of one or a couple of states. So it's like a necessity to have that strong international cooperation of the community, of the international community, to prevent, reduce, and eliminate harmful effects of environmental degradation and pollution as well. And according to this principle of cooperation, states have a duty to work together in all circumstances and in good faith to protect the environment. I mean, if you've done contract law, you also recognize these terms from that as well. Having a duty of cooperation and one of good faith, very kind of vaguely similar ideas for international law as well. And this idea of international cooperation is formally recognized in various other fields, which are also international law is involved in regulating, such as information exchange, technology transfers, financial resources, participation in international conference, and also emergency assistance through bilateral and multilateral agreements as well. Now, the next principle, that of sustainable development, is also vital and is confirmed in many international legal instruments, including in the Rio Development of the Rio Declaration of 1992, which I mentioned before. And I do have a broader focus on sustainable development in one or two slides' time as well. But just for the moment, for the purposes of this discussion, according to this principle, states should review their policy and plans for the environment and development to try to enact effective laws and regulations that use economic instruments where appropriate and establish institutional structures and procedures to integrate these environmental and development issues into all decision-making spheres. And the integration of environmental, social, and economic policies in this broader idea of sustainable development also needs to have, a good deal of transparency and have the ability for the broader public to actually participate in decision making on development and on the protection of the environment. So this concept of sustainable development, how it's been expressed in a lot of international law instruments, is that it's like an evolutionary process that meets the current generation's needs, but doesn't diminish the ability of the next generation to also meet their needs as well. So, express it another way, it's an opportunity for everyone to be able to live on the planet comfortably, not just now, but also into the future. And this is really one of the most fundamental issues of international environmental law. And we also look at this in the recent ICJ case on climate change in our tutorials as well. But there's a lot of challenges for this kind of, or this idea of sustainable development in its form and in its content. And arguably in its content as to what, sustainable development is. Many scholars have said it lacks a comprehensive approach for including Indigenous peoples, local cultures, and also freedom of expression, employment, the things we need to do to produce goods and services, and also identifying the roots of poverty and gender discrimination as well. So it can be seen as a bit of a catch-all term that doesn't really take in the particularities of the discriminations and issues that occur in societies to inhibit certain people's development. But we'll come back to this idea of sustainable development soon as well. Now, prevention, which I think your textbook led with, it's regarded as like the golden rule in international environmental law based on economic and ecological reasons. For instance, the extinction of plant or animal species, soil erosion, loss of human life, leakage of pollutants into the sea creates irreparable damage that even when the damage can be compensated, for example, restoring them to their previous state is no longer possible. And so this prevention principle in international environmental law exists to prevent national and transboundary harm due to the activities of states. And it forms the basis of many environmental agreements and conventions, such as the Basel Convention on the Control of Transboundary Movements of Hazardous Wastes and their Disposal, which we'll touch on when we look at the disposal of chemicals and other hazardous wastes. And the principle in this particular circumstance aims to minimize hazardous waste generation and combat illegal dumping because, it has irreparable damage to the environment and it's important to prevent. So, like I said, it's the golden rule and a really important principle of international environmental law because a lot of time compensation, for example, won't really do the job. Now, the precautionary principle, also mentioned by your textbook, this imposes a duty on states to prevent environmental damage. And under this rule, a state may be kind of obligated to take precautionary measures to prevent damage within its jurisdiction. Um, and there's a number of international environmental treaties that confirm this duty and its status as a principle. So, for example, in Article 3 of the United Nations Framework Convention on Climate Change, it says that the parties should take precautionary measures to anticipate, prevent, or minimize the causes of climate change and mitigate its adverse effects. Where there are threats of serious or irreversible damage, lack of full scientific certainty should not be used as a reason for postponing such measures. Take into account that policies and measures to deal with climate change should be cost effective so as to ensure global benefits at the lowest possible cost. So this idea of like taking precautionary action, even if we don't know the full amount of damage, the total science might not be settled, is really important. And then we also saw that in the so-called like second generation of our development of international environmental law, where even in the 60s and 70s, there wasn't the widespread understanding of ecological harm that we have now, but very much so the scientists, activists, and the broader movement at that time focused on a precautionary approach in that they didn't have all the information there, but it seemed like there was ecological damage occurring on a really widespread scale and something had to be done. Now, the principle of notification, now we're moving a little bit further down our list, is one of the basic principles that can be traced back to the International Court of Justice, actually, from the 1949 Corfu Strait case and other international sources as well, such as environmental treaties and agreements. And according to these principles, states must notify and share relevant information in a timely manner with every state that may be adversely affected by its environmental activities. So states should like notify other states if there's any kind of like natural disaster or other emergencies that may produce some kind of transboundary effects. And this is especially the case when there has been like a nuclear accident or there's a large incidence of some kind of transboundary pollution. And this also relates quite closely to our principle of cooperation, especially because it's based on a system of information sharing, prior consultation, and notification to achieve the optimum use of natural resources without causing damage to the legitimate interests of other states as well. Now, the second last one I have here on the slides is the polluter pays principle. Again, very much set out in lots of national and international regulations. And this principle says that polluters must bear the costs of that, resulting from measures to prevent, reduce, and fight pollution. And this principle was adopted formally by the Organization for Economic Cooperation and Development, or the OECD, which is kind of like representative of the so-called developed world in 1972, as an economic principle for allocating the costs associated with pollution control. There was a declaration of the United Nations Conference on Environment and Development in 1992 that also recognized this principle as one of the 27 guiding principles for future sustainable development. And according to Principle 16 of this particular declaration, it says, national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments, taking into account the approach that the polluter should, in principle, bear the cost of pollution with due regard to the public interest and without distorting international trade and investment. Now, finally, for our principles, there's a principle of common but differentiated responsibilities. This is sometimes has been shortened to CBDR. So this principle states that all states are responsible for protecting the environment, but with different types of responsibilities. So developed countries have a more significant burden due to their historical contributions to environmental degradation. And so they should assist developing countries with transferring new technologies and supporting them financially. And according to Principle 7 of the 1992 Rio Declaration, states should cooperate in a spirit of partnership to conserve, protect, and restore the health and integrity of the Earth's ecosystem. And it goes on to note that given the diversity of roles played in global environmental degradation, states have common but differentiated responsibilities. Um, and importantly for this too, the developed countries recognize, their responsibility in the broader international effort to promote sustainable development, given their own society's pressures on the global environment and the technology and financial resources at their disposal. And this principle recognizes that developed countries have benefited from centuries of exploiting natural resources and using fossil fuels, resulting in a disproportionate share of greenhouse gases in the atmosphere. And in this particular perspective, this principle was later embedded into the 1997 Kyoto Protocol, which set binding emission reduction targets for developed countries. And based on this, developed countries are responsible for reducing their greenhouse gas emissions by an average of 5% below 1990 levels over the period from 2008 to 2012, whereas developing countries were not subject to these binding emission reduction targets, but were expected to take voluntary actions to address climate change more broadly. So you can also see this operate today as well at the various UN-related conferences on the environment. There's usually always a question of, how much should the so-called Western countries take up of dealing with this global challenge, and then how much should fall to developing countries. Because it's also important here in terms of development as well, so-called developing countries want to be able to develop their economies so that they can be at the same development level as the so-called global north is. And so there's this paradox here where the Western states also generally want to help the so-called developing states develop, but also want to ensure that they don't contribute more pollution to the broader processes of climate change. And this is also can be very frustrating for so-called developing countries because it feels like their ability and means to develop is being restrained. So it is a bit of a complex tightrope to walk on with many intersecting issues. Now, on that note of sustainable development as well, I mean, this is an important concept just to dwell on for a little bit, because in terms of how sustainable development fits in the law and international law more broadly, it kind of sits at the intersection, arguably, between the integration of international economic, international environmental, and also international social law. And the idea of sustainable developmental law is an emerging kind of body of legal instruments, norms, and treaties, which are supported by distinctive procedural elements. And this idea of sustainable development is usually an agreed upon objective of many international treaties. And contributing to this area of law are examples such as 2015 United Nations Agenda, Transforming Our World, the 2030 Agenda for Sustainable Development, where the SDGs came from. It's in the name of them as well, the Sustainable Development Goals. However, as I hinted at before as well, defining what sustainable development means and the law surrounding it, what it encompasses, what is being referred to, what is being discussed can be really unwieldy. And so fundamental to an understanding of sustainable development and the law around it is the necessity to conceptually understand the principles of sustainable development that underpins the law or the legal regime around the concept. And one of the things that I mean I like to do to talk about how to understand the concept is think about its history and where it's come from. What does it look like today? And one of the early kind of formal reports that contain this term of sustainable development and is really recognized as creating the term formally was the 1987 Brundtland Report. I don't know if I'm saying that right, but Brundtland Report. And this report was the outcome of the work of, excuse me, the United Nations World Commission on Environment and Development, which is established earlier in the 1980s, which was brought about by a resolution of the General Assembly of the United Nations. And this World Commission on Environment and Development was established in the background of two emerging global themes at this stage, which also kind of builds on, what I mentioned around that second generation of development of international environmental law. So the first theme at this time was that it was generally starting to be more recognized that development wasn't a uniform, homogenous process that also benefited all people and nations, but is divided between, in one important metric, between developed and developing countries. And then the other global theme at this time was the kind of increasing recognition that the planet's resources are finite. And they require careful management. So this idea of sustainable development was formulated and formally written in this Brundtland report with these two different themes intersecting. But it also had some earlier histories where the concept was slowly being formed. And we can even trace it back to the 1970s, and again, where our second generation of international environmental law starts as well. And there's two really important developments here. The first one was the Club of Rome report, which is titled Limits to Growth, and then the 1972 United Nations Conference on the human environment. This is the Stockholm conference, which resulted in that Stockholm Declaration, which we mentioned before. And so the first one, this Club of Rome report, this was really crucial because it forecasts that unless countries learn to recognize and respect absolute limits to growth, there would be widespread economic, social, and environmental collapse. And in a similar way, that Stockholm Declaration that we've already talked on, Principle 13 urged states to, and I'm reading it out here, adopt an integrated and coordinated approach to their development planning so as to ensure that development is compatible with the need to protect and improve environment for the benefit of their population. And also Principle 14 promoted rational planning as an essential tool for reconciling any conflict between the needs of development and the need to protect and improve the environment. The interesting thing, though, between these two reports, on one side, the Club of Rome report and then the Stockholm Declaration, did have, important differences. The Club of Rome report saw economic growth on a collision course with ecological sustainability, whereas the Stockholm Declaration wanted to kind of reconcile the two, that, you could have sustainable economic growth. And I think, if anyone has any kind of cursory knowledge of the global political economy today, you kind of know which one kind of was successful. It wasn't the warning of the impossibility of unlimited growth, which seems still to be the thought in a lot of mainstream economics. But then once this idea of sustainable development, which was expressed in those early 1970s documents, was formalized in the Brundtland report, this has now had really far-reaching implications on a global scale. It has formed the subject of 3 Earth summits in 1992, 2002, and 2012. It's been incorporated into a multitude of international agreements. And also has been considered in international and national jurisprudence as well. And one of the most important expressions of this, of the influence of sustainable development was in the United Nations Sustainable Development Goals of Importance, or the SDGs. And like I mentioned, these emerged um, in after the 2010s. They were adopted in 2015, and they provided states with a framework for law and policy development. And there was 17. Still are 17 goals, which are usually, they're quite succinct, though they also have their flaws. They're not legally binding. They're not always well connected. They're often partially self-contradicting, and there's no real broader unifying purpose of them. So they also, these kind of factors make them vulnerable to political maneuvering, deviation, and also manipulation as well. And there's really no mutual understanding or agreed upon way as to how to achieve the goals and create sustainable development. Um, but the SDGs and I mean, we're kind of getting to the time where they are going to finish reasonably soon. In about 5 years or so, the SDGs will have done their term, and we'll have to see what happens then to, make these development goals or sustainable development goals more effective. Because just like the Millennium Development Goals, it seems like the SDGs will similarly be failing and also be falling behind where anyone really wanted them to be, unfortunately. Um, so yeah, it is quite, some of the SDGs are quite problematic, and the fact that we haven't had a lot of progress on them is also very harmful to the broader movement of sustainable development, and even for international environmental law as well. But this meaning of sustainable development and what exactly it is, like I kind of hinted at, has been the subject of lots of debate. But also its actual legal status in international law has also been under fire. Some scholars argue that sustainable development is a customary principle of international law, um, which is in the process of being established as binding on all but a few persistently objecting states, whereas other scholars say it's a general principle of international law, because it's got this broad and vague nature. Still, others say it doesn't really have any status. One of the important points where the sustainable development made an appearance in our international courts, and specifically in the International Court of Justice, was the decision by the ICJ in the Garb Shikovo Nagi Marosh case, which I hope I'm pronouncing correctly. And this was like I said, the first time it was recommended, it was expressly recognized in international jurisprudence. So the Garbishi Kovoy Na Gimarosh case involved a dispute over the construction of several dams along the Danube River. So I'm already kind of a bit dyslexic, so I do have trouble with some of these names. So please forgive me, and I hope I haven't offended anyone by pronouncing those really poorly. But Hungary and Czechoslovakia, in this case, had entered into a treaty agreement to build and jointly operate these dams that were being built along the Danube River. But then after a bit of a period of construction, Hungary suspended work on the project in 1989. And it did so because it judged that there was some potential for significant environmental harm to the ecological river system and its biological diversity, and to the water supply for Budapest. But then Czechoslovakia, and then after 1993, with the end of the Cold War, Slovakia, it proceeded with constructing one of these dams, the Garbi Shikovo power plant, which required the diversion of approximately 80% of the shared water into a bypass canal on Slovak territory. And then kind of in response to this, Hungary purported to terminate the treaty, the 1977 treaty that it had with previously Czechoslovakia. And then Slovakia disagreed for that termination. And then the matter was referred to the ICJ. Now, the court itself didn't address whether this particular project was sustainable or not. The court did require the parties to look at the environmental consequences of the project and to find a satisfactory solution that took account of the objectives of the original 1977 treaty that they had signed to develop these resources, as well as explicitly the norms of international environmental law and the principles of the law of international watercourses. And we talk more about the law of water in a sense next week, although it's more the law of the sea. But I mean, they'll come up. Um, so this majority decision in this ICJ case, sorry, didn't go as far as to acknowledge sustainable development as a legal principle. There was an important addendum, sorry, where the vice president of the court, Mantri, they took the matter of sustainable development further. And his separate opinion, he stated that sustainable development was more than a mere concept. It was a principle with normative value, which is crucial to the determination of this case. So, which was quite an important quote and showed the importance of sustainable development to the jurisprudence for international environmental law more broadly. So this idea of sustainable development and the law surrounding it, which some scholars have called sustainable developmental law, it's an emerging body still. And there's some substantive law behind it, which kind of sits between the economic, environmental, and social areas. So importantly, in this area of law, it's vital to know what sustainable development means, even though there's been lots of debate and still is around this concept as well. But this area will be more and more important, especially as we are probably going to be seeing the failure of the SDGs, and then thinking about what comes next and how and if sustainable development fits into that. So now let's talk about some selected environmental law issues. Again, I'm kind of covering the similar ones that your textbook has, but just trying to approach it with a slightly different angle, maybe pointing out different aspects as well. So firstly, greenhouse gases and climate change. So this relates very strongly to our broader focus on climate change in this lecture. And as I noted, it's one of the most significant issues of our time at the start, and where we're still struggling to find any kind of solutions. And there are a lot of definitions of exactly what climate change are, but I'm kind of taking the definition that there's where there's a buildup of greenhouse gases in the upper atmosphere. And these greenhouse gases do occur naturally. They play an important role. They trap some of the sun's warmth and ensure living conditions on Earth. But over the last 2 centuries, industrialization, deforestation, and agriculture has resulted in excessive production of large quantities of these greenhouse gases, which have now accumulated to really dangerous levels. And there's now a scientific consensus that the Earth is teetering on the brink of a catastrophic precipice as a result of the impact of climate change, which has been occasioned by this excessive emission and buildup of greenhouse gases. And so that's why there's been so many urgent calls to reduce quite drastically the emission of carbon into the atmosphere. And while the Earth has been impacted by human-generated greenhouse gases for quite a long time, most of the, and well, certainly since the 1800s, most of the increase in the planet's temperature has occurred in the last 35 years. And a lot of this is the result of activities such as the combustion of fossil fuels for transportation and the generation of electricity. And the combustion of fossil fuels results in the release of several of these gases into the various layers of the atmosphere, such as carbon dioxide, methane, nitrogen oxide, chlorofluorocarbons, hydrochlorofluorocarbons as well, and hydrofluorocarbons and carbon soot. And then when ultraviolet rays or radiation from the sun is reflected back to the atmosphere by the Earth's surface, these gases retain the heat. And so a high concentration of these greenhouse gases means a high retention of heat. It doesn't just mean climate change results in global warming. The physical changes also include warming oceans, decimation of ice sheets, reduction in the glaciers around the world, which bring a rise in sea levels, altering meteorological patterns with more frequent extreme weather events as well, which obviously seriously impact people and communities because they occasion really devastating conditions such as droughts, which may result in famine, flooding, which might result in displacement of communities, loss of land, as well as heat waves, which cause direct impacts on people and increase disease vectors as well. So it's obviously a significant problem. And we've noted already some of the legal regimes that have been crafted to address this issue, such as the Kyoto Protocol and the Paris Agreement as well. And the Paris Agreement is probably still the most spoken about and most impactful and vital movement on this front. And it has been commended as supposedly being a bottom-up, more inclusive approach. And it tries to deal with some of the issues around the Kyoto Protocol because it allows all parties to nominate what's called their nationally determined contributions, which are basically like climate action plans that countries submit under the Paris Agreement to outline their commitments to reduce greenhouse gas emissions and adapt to climate change impacts. And these plans detail the country's targets, their policies and strategies for achieving the goals, and they're required to be updated and then made more ambitious every 5 years to collectively drive global actions towards the goal of limiting global temperature rise to well below 2 degrees and ideally 1.5 degrees above pre-industrial levels. But this particular strength of the Paris Agreement has also considered a significant weakness because, as many of us have probably seen in the various climate negotiations, some of the highest emitters of greenhouse gases have demonstrated really minimal propensity to scale them down. And so allowing countries to develop and implement their own nationally determined contributions is working against the urgency that the prevention of anthropogenic greenhouse gases require. Looking at trackers of nationally determined contributions, it won't be sufficient what states are doing now to limit global warming to the aspiration expressed by the Paris Agreement, which I think we've maybe already even gone past already, which is required to prevent catastrophic impacts. And so these need to be increased significantly, and for governments to match, political will with the urgency that scientists say is required to battle climate change. But there is a big disconnect between not on one side, scientific demands, big mobilizations around the planet, and then the outcomes of global climate negotiations. And these must be addressed so these goals can be achieved. And I mean, one of the issues like we are discovering in most of our international law areas is that there's a lack of enforcement mechanisms, which makes it difficult to hold states to account. But having said that, the Paris Agreement has been widely endorsed. Over 189 countries have prepared nationally determined contributions, and they have been updating them and recommunicating them at frequent intervals. And it's still hoped that parties will take a more ambitious approach, but there's also a recognition that time is running out. And even for the broader international legal community who are working in this space to address climate change, the way forward is quite unclear. The legal regime for climate change has been considered part of international environmental law, as we've been discussing here, but it seems to be emerging in terms of climate change law itself as a distinct regime, which addresses a specific problem that needs focused regulatory attention. And this has kind of been fragmenting the broader international environmental law area and causing new branches of international law to forge their own identity, kind of separate to the broader framework of international law. So it's quite interesting where this phenomena, where there's like all this like regulatory legal work focused on climate change per se, which has kind of been divorced a little bit from these broader focuses on international environmental law, which does have the potential to conceal kind of intersectional nature of the challenge of the impact of climate change on the global system, which we mentioned at the start of the lecture in terms of how climate change impacts like different peoples and different countries that sometimes a overly regulatory focused on climate change might miss. Um, so it's imperative that lawyers working in this space also see how climate change also intersects with like international law around trade, human rights, intellectual property, humanitarian law, and those kind of areas, and see where those spheres over like interact, so that the idea of climate being a global concern should continue and be something for all to address. Now, in kind of similar vein, the regulation of atmospheric pollution is also really vital here, and it's one of the earliest and best developed areas of international cooperation regulation in the field of international environmental law. Atmospheric pollutants, by their nature, as we all know, can easily cross national borders, which create the need for agreements between states on how emissions are handled. Um, and so most of the rules in this area are found in treaties. Even though customary law still applies, but we do find a lot of these rules in treaties. And arguably, some scholars have said that even the broader field of international environmental law actually originated from the need to protect joint atmosphere between countries. And one of the earliest cases between states actually related to this transboundary air pollution. In 1941, there was the Trail Smelter Arbitration Award between Canada and the United States. And the arbitral tribunal's decision laid down what many, consider to be a fundamental principle of international environmental law, the obligation to prevent transboundary environmental harm. And this dispute arose around a Canadian lead and zinc smelting complex in British Columbia in Canada, which was emitting a significant amount of sulfur dioxide fumes. The United States complained that the sulfur dioxide was carried on the winds into Washington state, damaging farmland and forests. And then there was a joint commission made for the two countries, but the United States was dissatisfied with the recommendations of it, and it pushed for the negotiation of a convention whereby Canada would pay $350,000 for the damage caused from this movement of fumes across the border. And the US and Canada then agreed to submit to international arbitration. Um, and the arbitral tribunal was charged with devising a solution that was just to both parties, recognizing their state interests in both economic activity and environmental integrity. And the tribunal found that damage had been done to land and various adjacent areas in the United States since 1932. And it awarded damages, not quite as much as the US wanted, but still a significant amount of that time, with interest as well. And most critically for us, it found that there was an adequate basis to conclude that under the principles of international law, no state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes in or to the territory of another, of the properties or persons therein, when the case is of serious consequence and the injury is established by clear and convincing evidence. And similarly, another kind of emerging problem in the mid 20th century was the phenomena of acid rain, which had become a severe problem in Europe by the early 1970s, and especially with the acidification of Scandinavian lakes. And acid rain is kind of like the precipitation that countries that have elevated levels of nitric and sulfuric acids from the combustion of fossil fuels, which then can acidify water bodies, damage trees, destroy forest soils, building materials and surfaces, and degrade visibility and also impact human health. In the late 70s, 32 European countries, along with the United States and Canada, adopted a convention on the long-range transboundary air pollution with the United Nations Economic Commission for Europe, which set out a regional framework for countries to cooperate on the issue of long-distance acid rain. Um, and a feature of this convention, it's really wide scope in terms of the pollution covered. The title refers very specifically to transboundary air pollution, but its provisions apply simply to just air pollution. So its application not just dependent on proof that a pollutant has crossed a state boundary. Um, and the definition of air pollution didn't indicate any particular like severity or type or level of harm, which gave this convention a very broad range of potential applications, not just to acid rain. And in this convention, it was called that parties should try to limit as far as possible and, especially reduce and prevent air pollution, including long-range transboundary air pollution. So there wasn't any specific reduction target or timetable, but a more of a soft commitment. But it was actioned relatively effectively. And around this time, this is again when we spoke about the history, is exactly when evidence was mounting on the dangers more broadly about climate change more globally, and especially, excuse me, depletion of the ozone layer. And at this time, and I mean, that's been confirmed since, like acid rain, ozone depletion was believed to be caused by air pollution. Um, and again, from the anthropogenic emissions of GFGs, the greenhouse gases. And however, unlike acid rain, ozone depletion was not just like a localized or regional problem, but a global problem with both producers and users all over the world. And so this ozone regime had to secure buy-in from the whole of the international community rather than just a convention for the acid rain for the European states, which is a much more difficult task for the wide range of needs and circumstances that had to be accommodated to achieve some kind of consensus. Um, and at this stage, the ozone negotiations brought to the fore the challenge of reconciling environmental conservation with economic considerations. That there's that rift that I mentioned before that cut directly along a developed and so-called developing country divide. Um, and interestingly enough, by the early 1980s, the United States had actually already acted unilaterally to curb greenhouse gases, and especially CFCs, which is like the chlorofluorocarbons, which I think were found in like fridges and those kind of things. Um, and the United States were eager for others to follow suit as well, and pressured the Europeans who were a bit slow to come on board. But it was the developing countries who had argued that the ozone depletion was actually the result, and they're right, of the historical emissions of the industrialized North, and that it'd be unfair to hamper their economic growth with burdensome obligations and the outlawing of useful chemicals before they too had a chance to develop. Um, so this was complex, and I mentioned this contradiction before because there needed to be a truly global commitment. But by the mid 1980s, the international community finally agreed on a framework convention that was similar to this regional one for acid rain in Europe, because it laid out some kind of foundation for countries to meet regularly to review the state and the science of the ozone problem, and leave concrete reductions obligations for future protocols. Um, and this Vienna Convention of 1985 for the protection of the ozone layer was the first international treaty focused on addressing specifically and exclusively a global environmental threat. And is also important because it was adopted at a time when the science, again, like I mentioned, was a bit uncertain. But still, the international community moved forward with efforts to try to reduce the problem, build up scientific consensus as well. And so this was again an illustration of that precautionary approach, which I mentioned before, um, which had groundbreaking calls for also special consideration of the needs of the developing world um, in the development, exchange, and transfer of legal, scientific, and technical knowledge to try to like address this problem. So this is quite a relatively remarkable international regime, which I mean, kind of be hard to imagine would kind of get up now. Uh, And then it kind of laid the basis of ideas around like common and differentiated responsibility that would be articulated in the Rio Declaration a few years after this time. So it's a very important initial treaty in this area. Now, chemicals and waste, another really vital point as well, because following the Second World War, there was growing industrialization in developed countries that led to a huge surge in the manufacturing use of synthetic chemicals, pesticides, and other lethal concoctions. Um, and there's also this kind of like unmasking of some of these toxic chemicals, which were known to be useful in industry, but there was a lot of ignorance around the actual impacts that they had. And one of these, for instance, was a pesticide called dichloro trichloroethane, which was a kind of miracle pesticide because it supported industrialization and economic growth, but it was then found out that it actually posed totally unacceptable risks to health and environmental sustainability. And these kind of revelations unleashed a really intense national debate in a lot of the so-called industrialized countries regarding the dangers posed by these substances, leading to some kind of regulation. But because there was regulation in these so-called industrial countries, the industries responsible then just simply started to move to the so-called developing countries, and then tapped into the kind of global market at this time to enable the export of these toxic chemicals and pesticides to other markets in so-called developing countries. And if this regulation was difficult to bypass, they would just simply move their supply chains to different countries that didn't have the same kind of regulation. Um, and so, because of after decolonization for many countries, and with their increasing poverty, increasing problems of development, these countries, welcomed the industrial toxic industries into their territories. But because many of these countries had ineffective laws, poor regulation, it allowed these hazardous industries to operate in a manner that endangered human lives and polluted water, air, and soil. A really early example of this was the Bhopal gas leak of 1984, which saw the release of deadly methyl isocyanate from an industrial plant, which is owned and operated by a US company in the Indian city of Bhopal. And the disaster left thousands dead and even more physically impaired, which is one of the worst industrial accidents in human history, which is kind of a legacy demonstrating the dehumanizing impacts of toxic technologies and hazardous chemicals. Um, and so there's been ongoing issues of companies based in the so-called industrial countries, basically like dumping their hazardous chemicals in developing countries where the regulation isn't as strict. And it's been like whitewashed in a sense as economic assistance to developing countries as well, even though the hazardous nature of these have persisted. Now, the international legal regime on this subject consists of a few multilateral environmental law agreements, such as the Basel Convention on the Control of Transboundary Movements of Hazardous Wastes and Their Disposal, which is also just the Basel Convention, the Rotterdam Convention on the Prior Informed Consent Procedure for Certain Hazardous Chemicals and Pesticides in International Trade, or the Rotterdam Convention, and the Stockholm Convention on Persistent Organic Pollutants, or the Stockholm Convention. So these three conventions form the cornerstone of the blueprint for the regulation of the production of harmful chemicals and their disposal, and also international trade in their substances. And this is generally geared towards regulating state behavior. And it's been really, this regime has been formed out of an inability for states to respond unilaterally to these problems that are, transnational in character, and it's kind of ingrained in this idea of cooperation, which is one of our really important principles. And sorry, my cat's just being very naughty. But this regime of these three treaties has been really vital as well. And we don't go into this in a huge amount of detail as well, but they do also, I mean, relating back to our previous discussion, do try to aim for this objective idea of getting some kind of sustainable development by balancing protection of human health and the environment as against this kind of idea of international free trade and investment because of the harm of these chemicals. Now, our second last point is the conservation of biological diversity. And this is also a point that's really integrated into international environmental law. There's a really large imperative for biodiversity conservation, which derives from the premise that every life on Earth is dependent on a healthy biodiversity. And its conservation is critical to the preservation of natural resources as well. And all stakeholders in the international community deserve to be equitable beneficiaries of biological resources as well. And it's also a critical component of sustainable development and biodiversity conservation as well. Now, the main kind of international environmental law around this area is the Convention on Biological Diversity. And this came into force in the early 90s in 1993 and underscored a really urgent need to reverse the alarming tide of biodiversity loss. And there was two really important developments on the urgency to implement this. And the first was the advent of modern biotechnology, which saw biotechnology as an application that uses like biological systems, living organisms, or derivatives to make products usually for scientific use. And this convention was negotiated during an era designated as a biorevolution. Life forms became a dominant site for unprecedented research and development with cross-sectoral impacts on food, agriculture, health, pharmaceuticals, and so forth. And the rapid uptake and transboundary transfer of these biotechnology products across lots of contexts raised several human environmental safety concerns. Uh, uh, and all of these weren't actually, considered by the time the convention was agreed. And the second development was the recognition of the contributions that Indigenous peoples and local communities and their knowledge systems had to biodiversity conservation as well. And this reinvigorated interest of scientific communities in research and development and their connection to experiences, insights, and practices of Indigenous peoples and local communities in their traditional lands and resources. And there's kind of been an ongoing tension since this time between, especially around intellectual property rights, which again, we can't get into really too much here, but is a very interesting topic in and of itself, in extending patent regimes to life forms and in failing to recognize Indigenous peoples and local communities' long established innovations and practices via traditional knowledge and dealings with genetic resources, and also of like international property rights being used to capture these resources. As you can see this most prominently in like seeds, for example, where seeds have been developed over millennia by Indigenous peoples and local communities, which are then kind of taken by multinational corporations and had their intellectual property stamped on it. Where this intellectual property system is perceived as a tool and used as a tool of exclusion, where these biocultural knowledges are appropriated. And this is known as bioprivacy, not privacy, biopiracy, rather, excuse me. And so there has been some responses to this. So one of the most important was the Strategic Plan for Biodiversity from 2011 to 2020 and the Aichi targets, living in harmony with nature. And these were developed pursuant to the United Nations Decade on Biodiversity, which ran from 2011 to 2020. And these targets encapsulated concrete elements of an integrative approach to biodiversity conservation as a practical and inclusive matter. Which had a very clear vision and mission with 5 goals with lots of very ambitious targets as well, which was to kind of serve as a strategy to promote the implementation of the Convention of Biological Diversity as well. And then there's been lots of other institutions and groups who have monitored the impact of this convention and the Aichi targets as well, and especially in the context of the SDGs. Now, finally, on land degradation, this has also been a really vital topic as shifting agricultural cultivation and slash and burn agriculture has been associated with widespread deforestation, land degradation, and soil depletion. And this is an important issue for us because I mean, soils and forests nourish human, animal, and plant life, and the ongoing degradation of soils has profound impacts on biological diversity, food security, rainfall patterns, and livelihoods of those dependent on agriculture, which is basically everyone. Um, and the expansion of agriculture and forest productivity has also, in a kind of reciprocal, contradictory manner, also has produced more greenhouse gases, which has then impacted soil degradation. So it's kind of a little bit of a cyclic process because land is both a source and a sink for greenhouse gas emissions, and it's vital to the exchange of energy, water, and aerosols between Earth's surface and the atmosphere. And one of the main issues here is the soil desertification, where there's been a spread of desert-like conditions in dry climates, which can be irreversible and results from a combination of human activities and climatic factors as well. And each year at the moment, 12 million hectares on Earth becomes barren due to drought and desertification, which represents an estimated annual lost opportunity to produce about 20 million tons of grains. And Indigenous knowledges and cultures have long understood the profound importance of soils for ecosystems, especially within agricultural contexts. And unfortunately, having said that, this hasn't always been and really rarely taken up into international environmental law and in broader systems of governance. For example, former Food and Agriculture Organization of the UN Director, Jose Graziano da Silva, describes soils as a nearly forgotten resource. And scholars have said soils continue to be overlooked, neglected, undervalued, and especially Indigenous knowledges and practices continue to be totally underappreciated in looking after soil. But it's a really important emerging part of international environmental law. And most recent governance responses has tried to focus on increasing awareness about the importance of soils and trying to find some kind of goal of sustainable soils management. And even the General Assembly in 2015 declared that year to be the International Year of the Soils. And the Sustainable Development Goals also has a few targets that directly reference soils as well. And the Food and Agriculture Organization has been at the front line of trying to address this. So they're kind of all of the select environmental law issues. And I mean, as we go on, you'll see that, international environmental law is a really increasingly relevant discipline. It's it is kind of a bit of set on a bit of a crisis mentality because there's a lot of failures and it's very slow change occurring. But I mean, there still has been a lot of progress in terms of international environmental law over the last few decades. Even it might not be the impact of climate change itself, certainly in the international law architecture and regimes, there's been huge developments as well. Today even we see, young people who are taking this fight a lot more strongly, and they advocate for global environmental protection. Greta Thunberg, as well, one of the most prominent and famous activists on climate change at the moment, has also called for more action on this issue. And her example, as well as many others, have inspired, millions around the globe as well. So there is also an urgency for us in the legal fraternity practicing international environmental law to heed these calls and try to be much more proactive rather than reactive about, the changes we're seeing. But anyway, this is, I think, all for us for the moment. We've got our tutorials coming up this week. We'll probably focus on the most recent ICJ case in this area, which is kind of takes up most of your readings actually this week. So we'll probably be looking at this case in a lot more detail. So please do try to read, especially the required readings on this before we get there. But thank you so much, Sam. I look forward to seeing you after the break.